Jacob Zuma versus the IEC has reached its highest level at the Constitutional Court. Let's distill the issues in that case, understand the legal questions and the political questions and how they come together. Let's get into it. Spread the fire. Welcome back to SMWX. And if you're new around here, my name's Dr. Sizwe Mpofu-Walsh. On this channel, we explore South African politics through interviews and analysis. Please help us get to 100,000 subscribers, by the way, by subscribing. We're trying to get there by the 29th of May, which is the date of this election. Okay, in today's episode, we are going to take a look at probably one of the most important moments in South Africa's election. Jacob Zuma is going to the Constitutional Court to try to make sure that he can be on the MK party list to go to Parliament. This has massive legal implications as a crucial constitutional case, which calls into question the interrelation between several constitutional rights, but it also has massive electoral and political implications. And today, as you are probably watching this case, or if you've just finished watching it, as I know it'll be big in the news cycle today, as we release this on the day of the hearing, I want to help you understand the issues and try to clarify and simplify them for a non-legal audience, and indeed for the lawyers who watch this channel, who I know are great commenters down below, and also to understand the politics. So I think there are a lot of people who analyze this case from a legal perspective. There are a lot of people who analyze the politics, but it's important to understand the interrelation between the two, and that's what we're going to do in today's episode. So we're going to start with the law, and then we're going to move on to the politics. So to begin with the law, let's first take a look at the background and how we got there and where this case fits in the cases involving the IEC and the MK party and indeed the ANC as well. And once we do that, we'll then come to this particular case, why it's before the ConCourt, and what the issues that the ConCourt must decide happen to be. Now, there have been a number of different cases. I'm sure you've heard about MK Party, ANC, IEC. There are effectively 3 cases, 2 of which the MK has won. And this third one, the MK won at the Electoral Court, but it has been appealed to the ConCourt. So the first case was about the registration of the MK Party. The ANC said MK was improperly registered, and the Electoral Court found against the ANC on that. So that's case number 1. Case number 2 was about the trademark of the MK party, its name, its logo, and whether it could use that or whether that infringed on ANC rights to those names and logos. MK party won that. I think the ANC is appealing it, but the MK party won that. So we know that the MK party will be on the ballot, and we know that they will be using the name and the logo that they have used up to this point. Now, this case is about whether President Jacob Zuma can be on the MK party list to go to Parliament. So as you may know, parties submit lists of candidates who may or may not end up actually going to Parliament. And the MK party has former President Zuma at the top of its list. So the MK party is essentially saying that if you vote for us, we will send President Zuma to Parliament. Now, the IEC has challenged former President Zuma's ability to stand as a candidate on the MK party list for the following reason, and this is what this case centers around. It centers around the interpretation of a constitutional provision, and that constitutional provision concerns who is allowed to be a member of Parliament. It's section 47(1)(e) of the Constitution. And that section effectively lists a number of people who are ineligible to be members of Parliament. So people of unsound mind, unrehabilitated insolvents. But importantly, it includes a disqualification for people who have been sentenced to 12 months or more by courts, convicted and sentenced. And then there are some provisos around that in terms of appeals and lengths of time after those appeals. So if it's 5 years after you've served your sentence, then the disqualification falls away. Those are all details, but at the essence of it, you can take this case as, how do we interpret this section that disqualifies people who have been convicted and sentenced of offenses? And how does it relate to President Zuma? Now, the IEC says that we must interpret this narrowly to directly exclude Zuma from holding office. Whereas the MK party and Zuma are saying we should interpret this expansively to enlarge the scope of the political right to stand for and hold office, which is enshrined in Section 19(3)(b) of the Constitution. To make matters even more interesting, President Ramaphosa remitted Jacob Zuma's sentence. Now, exactly what that means is the subject of this ConCourt case. MK party and Zuma say when you remit a sentence, when you make someone leave incarceration early, you effectively change the length of that sentence. And what that means is that Zuma's sentence went from 15 months to 3 months. So he no longer falls within the scope of that constitutional section which disqualifies people for long sentences. Whereas the IEC says, yes, President Ramaphosa may have remitted Zuma's sentence, but that remission only changes the time served. It doesn't change the nature of the sentence itself. So that's, in a nutshell, what this case is about. It's a sprawling case which has a number of different issues, but if you can understand that issue, you get to the heart of the substance of the case and the heart of what I think the court will revolve its decision around. Having said that, I want to delve deeper into the case to give you an even deeper understanding. One of the interesting things that's going to happen in the hearing is that there will be a counter application, which is just a fancy way of saying an application within this court case, which has to be considered in and of itself for the recusal of several constitutional court justices. Now, the reason this is interesting is that many of the same constitutional court justices who convicted and sentenced Zuma to the 15-month term for contempt of the Constitutional Court, many of the same people are going to sit in this case. So Zuma is saying that because there is an intersecting set of facts in the case where he was convicted and this case, and because certain judges have already pronounced themselves on these intersecting set of facts which bear on the last case and on this case, he holds a reasonable suspicion that they will be biased against him on the same set of facts to the extent that they're relevant in this case. So he's calling for those judges who sat in that matter to recuse themselves in this matter because of the overlap of the factual context in both matters and the fact that they have already come to a predetermination on one case which deals with at least similar facts. The only difference in this case is that it bears on the same facts as the previous cases, but there are now new facts which have happened since his conviction and sentence. And crucially, this case considers a different question of law. So the previous cases considered the legal question whether Zuma should be convicted and sentenced. And we know now that the Constitutional Court did convict and sentence him. This case, although it's about the same facts, is not about whether he should be convicted and sentenced for contempt. It's about whether he should be disqualified from Parliament based on that conviction. So it's a really interesting moment in which we have a case that is about a different legal question, but in some ways about similar facts. So Zuma is saying those judges should recuse themselves because they've already made a determination on a set of intersecting facts. Now, what's interesting about this is a point that they make, which I haven't seen made much in the public debate, which I think will come to the fore in this case. Judge Daya Pillay was an acting justice in the Constitutional Court in one of the cases where the Constitutional Court ruled against former President Zuma. So like some of the other justices who are being asked to recuse themselves, she sat on the bench that day and made the decision. She is now a commissioner at the IEC, and she took the decision to recuse herself from the decision whether Zuma should be on the MK list. So we already have a judge that has recused themselves for exactly the reasons that Zuma would request these constitutional judges to recuse themselves. The only difference is it was in a different forum when she was sitting as an IEC commissioner. And the IEC has conceded that she recused herself for that reason. So the question then becomes, if Judge Pillay could recuse herself out of her own conscience without being asked to do so in advance, why should she have recused herself and these judges wouldn't recuse themselves? It's the same set of facts. It's the same situation. If anything, the question is probably more serious for the Constitutional Court justices because they are sitting in the same forum, which has already considered the same facts. The IEC will say exactly that. They'll say that this is a different issue. It's a different legal issue, and that judges often do consider questions on which they have previously pronounced. But the Daya Pillay example is going to be a tricky one for the IEC to try and work its way around, and I'll be interested to see how they do that. So I think this recusal question, which is going to come up front probably, will be a big question in this debate before we actually get into the merits of the remission and how to interpret Section 47(1)(e). And I think public observers haven't appreciated that nuance about how the Daya Pillay recusal bears on this case, and I think it bears very relevantly. So that's that important point. The second important point that I think is going to be key to this case in terms of the substance of the case is, of course, this question of remission of sentence and the true legal effect of remission. So the Electoral Court, which found for President Zuma in this question, in the majority on this issue, because this has been completely misquoted in the media, there are various different majorities on different issues that came out of the Electoral Court. So even though Judge Zondi wrote the majority judgment, he's actually in the minority on the remission point. But that's a technical detail. So in the majority judgment on remission, Judge Modiba and others came to the conclusion that remission does alter the sentence. In other words, President Zuma's sentence was not 15 months. Because President Ramaphosa curtailed that sentence to 3 months, it had a legal effect on the sentence and he no longer falls within the bounds of the constitutional section. Now, the IEC has launched an argument and KSAC has agreed with them. And there's been a big move by various civil society organizations to join this case. They've launched a move to say that that court is wrong. The remission of sentence does indeed preserve the original sentence. All it does is change the length of time. So there's going to be this big debate. How do we interpret the president's powers as they relate to Section 47(1)(e)? So there's going to be a conversation in this case between Section 84(2)(j), which is the presidential power conferred in the Constitution for presidents to interfere with judicial punishment, and then this provision about who can stand for parliament, Section 47(1)(e). So we have this really interesting case which actually involves all three different dimensions of government. It's got the judiciary and how it interprets, it's got the legislature and who's allowed to be in the legislature, and it's got the powers of the president. And so it's a fascinating constitutional case from that perspective. Now, there have been strong arguments made by both sides on this question, and it's going to be a fascinating debate. I happen to agree with the MK party, but it's a fascinating legal debate, and interested observers can disagree. The IEC and KSAC have made an interesting argument about previous constitutional history, and they've actually gone to the Constitutional Assembly deliberations and found in a footnote of one of the minutes of the meetings of the Constitutional Assembly that when you interpret remission, you should not consider that it alters the sentence itself. It merely changes the time served. So that would seem to be in the Commission and KSAC's favor. However, when you're interpreting the Constitution, to rely only on historical documents and footnotes in historical documents is not the ideal place to interpret. You would first go to the text of the Constitution. You would go to the context within the Constitution. In other words, where does this section fit in relation to other sections? And then you would go to case law. And then you would go to things like historical records, which might confirm. So the MK party is then going to say, well, if we look at the text itself, if we look at the context of the text, and if we look at case law, what we find is that South African law has pronounced that remission does alter the sentence. And so even if at the Constitutional Assembly there was this one view, the way that it has actually worked in the text in practice and in case law and in contextual analysis, remission should alter the sentence. Now, what is in the MK party's favor, and what you may see in this case if it does get to the merits, because remember the recusal application could go one way, which actually kind of stops this case right there. What is in the MK party's favor is also international law on the subject. So the Constitutional Court has actually said, what are the international examples on which we can draw that can help us make a determination? Now, fascinatingly, there was a very similar case which went before the UN Human Rights Committee. It's called the Disanayake judgment. And get this, exactly like President Zuma, there was a powerful Sri Lankan politician. Exactly like President Zuma, he was convicted and sentenced for contempt of court. Exactly like President Zuma, he was convicted for contempt of court by the highest court in the land. So his situation parallels very closely with President Zuma at this moment. And exactly like Zuma, he was disqualified for holding office. And exactly like Zuma, he got a presidential remission, which affected his punishment. So it's a very similar case to the current case that the Constitutional Court is facing. And the UN Human Rights Committee, which in turn interprets the International Covenant on Civil Political Rights, which is an important international law treaty, the Human Rights Committee found that to disqualify Mr. Disanayake from his important political rights was a violation of the covenant. So the MK party is going to say that the text of the Constitution, the context, case law, and international law, especially in cases that are directly factually similar to this, fall on the side of President Zuma. The IEC and CASAC are going to refer on a collection of foreign judgments, which they argue support their interpretation, and they have looked at cases from India and the European Court on Human Rights, etc. Now, the only difference is that the International Covenant on Civil and Political Rights is international law, which must be considered when interpreting the Constitution, according to Section 39, and foreign law only may be considered. What that really means is that international law has a higher interpretational status than foreign law. So as you can see, we have a fascinating conversation. We've got two interesting sides of a debate. Does the president's power to remit punishment overturn a judicial sentence, or does the sentence stand even if the time served doesn't stand? Now, there's an argument that has been made on the side of the commission and some of the intervening parties, which is about the separation of powers. So the president cannot interfere with the judiciary. I disagree with that point. If you look at Section 84(2)(j), it confers very wide powers on the president, and he acts as the head of state when he is exercising these powers, unlike some other powers. The whole point of not necessarily just remission, but let's call it clemency or presidential mercy, which includes pardons, remissions, and reprieves. The whole point is to interfere with the judiciary. So it's a power that's conferred on the head of state where they are able to temper extreme punishments for some public purpose. So to say that it is a breach of separation of powers, in my view, mistakes the whole purpose of the power. The purpose of the power is exactly to interfere with judicial punishments. Obviously, that has to happen within the context of the rule of law and legality. There have to be good reasons. Otherwise, the president's powers can be challenged and reviewed. But in this case, President Ramaphosa's remission wasn't reviewed. So I don't really buy the separation of powers infringement. I think the deeper debate is about whether remission itself has a legal effect on sentence or not. There are so many other things we could discuss, but I just want to make this relatively punchy for you. So I think those will be the key issues in the case. There'll be a counter appeal, so there'll be questions about whether the IEC actually has the power to do this or whether it should be the National Assembly. There'll be questions about the bias of Commissioner Janet Love in some of her public media statements. But for me, that's where the case really centers. Having said that, let me come on to the question of the politics of all of this. What the court decides here will have seismic political implications. There's no other way to put it. However, I think in some ways the MK party has put itself in a position that it can benefit from either decision. So if the court rules against President Zuma, judging by previous statements of the MK party and its supporters, you're going to see this narrative that the Constitutional Court has a grudge against Zuma. You can always predict what it will, no matter what case gets brought before it, no matter what precedent supports Zuma, the court will always turn to the harshest punishment and decide against Zuma. So politically, I think that's how the MK party would spin an adverse outcome. Of course, if they win legally, which is certainly a possibility as well, if they win because they won at the electoral court, if they win legally, that's going to be wonderful for them too, because they're going to be able to say, hey, look, we were vindicated. The IEC tried to stop Zuma from being on the list, but now finally he's on the list. History is with us. The momentum is with us. So politically speaking, although this is a really interesting legal debate, I think the MK party is extremely happy that this is happening because it keeps them in the headlines, it keeps them in the spotlight, and they will be able to exploit politically any outcome for their election purposes. Now, I have been one of the few analysts who has been saying that this has been a godsend for the MK party because the only thing at this point which can constrain the MK party's surge is its own political divisions. And people are looking at me crazily like, what political divisions? Well, now you've seen them come to the fore. We saw the former party leader, Jabulani Khumalo, being kicked out of the party, going to the IEC, saying that Zuma must be removed, and the IEC having to come out and say, no, Zuma is the registered leader of the party. So as you can see, it seems to me that there are internal battles within MK. What is preventing these internal battles from spilling over is that people keep uniting the MK party by taking them to court, in which case all the factions come together and rally around the party and rally around its leader. So this is going to have the effect just before the election when the MK party might otherwise have been quite internally fragile, no matter what the court rules, of creating a moment of unity for that party. And I'm sure former President Zuma is a political strategist. He will use this moment to his political advantage. Expect fireworks, expect spectacle, expect the use of this moment to benefit the MK party and President Zuma, and the use of all the attention that's going to be concentrated on the court to be translated into MK party momentum and support. So although this is an interesting case politically, it's also an interesting case legally. But I think the legal outcome is binary. Either the MK is going to prevail or it's not. I don't think the political outcome is very binary in the sense that I think whichever way this case goes, it will be good for the MK party. What wouldn't have been good for the MK party is if the IEC just accepted the electoral court's ruling and just let this thing happen, and then the MK party's internal battles would have taken center stage. But now I think the party will be further united by this, no matter which way it goes. In fact, you could probably argue they'd be even more united if the court rules against them. But that could be a funny, cynical take. So I'm sure we'll see some very fascinating and interesting things at the hearing tomorrow. It will probably be quite a historic hearing, although you just never know what could happen. You don't know what will happen with the recusal application and what happens from there. Those are just ways of thinking about this case as you watch the hearing, and hopefully ways that will help you to clarify both the legal ramifications that are under consideration and the political ramifications. Help this channel get to 100,000 subscribers. If you're listening on a podcast, give us a positive rating. Thanks very much for staying tuned onto SMWX. We appreciate all the views and the way this channel is skyrocketing to the top of various charts. Let's continue this conversation. We'll also be reacting to the hearing and what the court says and watch some of our other content on this subject. Spread the fire. Aye, keep it locked on SMWX.